The recent Supreme Court decision in Carson v. Makin has implications for Vermont's tuitioning system. I was familiar with our current system and laws that allow for providing tuition for students in districts that do not operate schools, but I was curious how we got here. My research took me all the way back to the Constitution for the Republic of Vermont and continued on from there. I reviewed acts and resolves of the legislature and old newspaper articles that pertain to tuitioning. This is not a comprehensive list of all of the events and legislative changes related to tuitioning. I'm certain there are things that I missed. But I hope that this covers the major moments in our state history related to tuitioning. It's presented as a timeline of changes. So let's get started with our timeline. The first stop comes as Vermont establishes itself as a republic. The original Constitution from 1777 contains the first mentions of schools and education, in particular, that it was the legislature's responsibility to ensure that a school or schools were established in each town, and each town was to pay for their school or schools. By 1786, that language had softened a little bit. The term shall be established was replaced with ought to be maintained. 2 years after Vermont was admitted to the Union, the Constitution was revised yet again, this time removing any mention of grievances against King George and also grievances against the state of New York, because New York had claimed that Vermont was a part of New York. What didn't change, however, was the language pertaining to education. That remained the same. It's interesting to note that the language referencing schools in the Constitution from 1777 to 1793 and beyond is included in the same paragraph referencing religion, encouraging the creation of religious societies for the advancement of religion and learning. The historical academies are important to our education and tuitioning system in Vermont. Historically, the academies were created by the legislature through incorporation. Thetford Academy was created in 1819 and in 1821 was declared the grammar school for Orange County. Burr Seminary, later known as Burr and Burton Academy, was created in 1829. The legislative acts that created these academies also specified the original appointees to the Board of Trustees for each academy. The acts also addressed how to fill vacancies on the boards and stated that meetings of the Board of Trustees needed to be legally warned. In 1841, the legislature allowed public high schools to begin to join together to form union districts in order to provide older students with practical and farming skills. This was different than the classical education that was provided at academies. While many school districts already imposed a local tax for the support of their schools, Act 27 also empowered the district to raise money for the support of schools via local property taxes. Then, in 1842, the Fairbanks family established the St. Johnsbury Academy, providing both college prep courses as well as vocational training. In 1860, the legislature approves the name change for Burr Seminary, becoming the Burr and Burton Seminary. All of the previous provisions of the 1829 Act incorporating the seminary remain the same. In 1864, we see a progression of how we fund education in the state. While previous acts provided for the collection of money in support of schools via property taxation, in 1864, Act 61 made it a requirement that all expenses incurred by school districts for the support of schools would be covered by a local property tax. Then, in 1869, we see the introduction of tuitioning. Act 9 allowed school districts in which there was an academy or an academy in an adjoining district to enter into an agreement to send their students there for instruction. The act also allowed for the payment of tuition to those academies using public money. In 1873, St. Johnsbury Academy is reincorporated by the legislature. Like the other academies, it has a board of trustees, and those trustees are required to legally warn their meetings. In 1890, we see the arrival of the statewide property tax to fund education. It was set at 5 cents on the dollar. The monies collected went to the state treasury, where they were then redistributed to the towns, cities, unorganized towns and gores, based on the number of schools they operated. An article in the St. Albans Messenger in December of 1890 reported the impact on Randolph. The new tax required Randolph to raise and send $1,000 to the state. The amount they received back, based on their 16 schools, was $570. The article reported that the remaining $430 went towards supporting education in the poorer towns in the state. Then, in 1902, we see tuitioning options expand beyond schools just in Vermont. Section 3 of Act 27 of 1902 explicitly allows students to attend school or academies both within and outside of the state. Just a brief aside, while reviewing the news related to this act, I stumbled upon a curious piece in the Rochester Herald from March 6 of 1902. At Randolph Town Meeting, resident L.J. Harrington complained to the school directors. He was seeking tuition reimbursement after sending some of his children to the preparatory school rather than the graded school in the village. The school directors denied payment, claiming that if they had allowed it, it would have opened the door to an expensive system. In one of the best lines I've read in a newspaper in a while, the Chelsea Herald reported that there was a great deal of eloquence uncorked in a brief time, after which the electorate voted to approve the reimbursement. In 1927, we see things expand slightly to allow for tuitioning upon approval of the board, even in cases where the district operates a high school. Based on news reports from that time, it appears that this was intended to meet the need for extraordinary circumstances and not the basis for a complete tuitioning system in the state. For many years after 1927, school districts across the state struggled annually with rising tuitions. Many districts argued that the tuition they charged was below the actual costs to educate the children. Each year, schools would increase their tuition costs, in later years attempting to cover the actual cost of providing these students an education. The legislature stepped in, establishing laws that limited tuition increases or outlined what costs could be factored into tuition. Receiving schools gradually found themselves at a crossroads. Many were bursting at the seams to accommodate their resident population in addition to their tuition students. Because of this, some districts eventually limited the number of tuition students they would accept. In 1953, the legislature established a state aid formula for distributing funding to schools. Then, in 1955, the Vermont Attorney General declares that school districts cannot count students being tuitioned to other schools. This dramatically decreases the amount of state aid received by those towns that tuition. South Burlington, which was a tuitioning town at the time, complains that the Attorney General's decision is unfair. In 1956, a case from South Burlington, Donahue v. Smith, makes it to the Vermont Supreme Court. The South Burlington Board felt that the Department of Education erred when it decided to discontinue reimbursements for students sent to non-public schools outside of their own towns. The Vermont Supreme Court narrowly ruled on the basis of the original 1949 state aid law, stating that state aid reimbursement for the publicly financed tuition of students sent to sectarian schools was illegal. Many were upset that the Supreme Court did not rule on the constitutionality of using local tax money to support sectarian education. This left the door wide open for a future case, a case that wasn't too many years in the future. In reaction to the Smith v. Donahue decision, the Vermont House attempted to address the issue during the 1957 legislative session. House Education proposed a bill that would confine tuition payments to public schools and academies. There was significant pushback. And in the wake of that pushback, the chair of House Ed claims that the intent of the original bill was unclear due to a printing error, and the bill was recommitted to House Education. When it reemerges, the language only references setting a cap on allowable tuition charges. Later that same year, the State Board of Education rescinds a previous rule and declares that towns that operate a public high school cannot tuition students to another district. And as for that open door from the Supreme Court, in 1961, that case makes it to the Vermont Supreme Court, and it's also from South Burlington. Plaintiff Raymond Swart brought suit against the South Burlington School Board objecting to tuition payments for town students to attend Mount St. Mary's Academy and Rice Memorial High School. This time, the Vermont Supreme Court rules unanimously that the use of public funds for students attending Catholic high schools was unconstitutional. The South Burlington School Board was not pleased with the decision and considered an appeal to the United States Supreme Court, but ultimately decided against that move as they were in the process of building a new high school in South Burlington, and with that change, would no longer tuition any of their students. The court's involvement in tuition issues continues when, in 1983, parents of a student in Thetford sent their child to the Richmond Middle School, part of the Dresden School District in Hanover, New Hampshire, rather than Thetford Academy, which was the designated school for the town of Thetford. The parents requested that the Thetford School Board cover the tuition costs, and both the Thetford Board and the State Board of Education denied the payment. The parents appealed the case to the Vermont Supreme Court. The court denied to hear the case, stating that they did not have jurisdiction in the matter, referencing the statute giving final approval to the board. In their response, however, the court noted that there is no constitutional right to be reimbursed by a public school district to attend a school chosen by the parent. In 1999, the legislature passes H. 286, an act on independent schools and academies, that recategorizes the historic private academies as independent schools. While this change garnered little attention in 1991, it is worth noting that it has significant implications in our current environment. Before this change, Bill Reedy, legal counsel for the Department of Education, noted in a memo in 1989 that the 5 historic academies, Burr and Burton, St. Johnsbury, Thetford, BFA, and Linden, were considered public schools according to existing state statute. Then, by 1993, 2 years after the passage of H. 286, Reedy sends a memo to Burr and Burton following a meeting with the school's administration, outlining their status as an independent school and their options under the new status for tuitioning and receiving public dollars. In that memo, Reedy described the requirements to receive public money and raised 2 items in particular that he felt Burr and Burton would need to address in order to receive public money. Number 1, that they accept all students with disabilities, and number 2, that teachers and administrators be certified. Reedy opined that the state board may be more flexible with the certification requirements than the special education one. It's the special education issue that becomes the subject of a court case 10 years later. The next Supreme Court case comes in 1994. Orland Campbell, from the tuitioning town of Manchester, sought to force the district to pay for his son's tuition to a private religious school in Delaware. The school district and the State Board of Education both denied the request, citing the religious nature of the school in Delaware. Mr. Campbell appealed that decision to the Vermont Supreme Court, which overturned the original ruling. But in doing so, the court emphasized that the decision only applied to this case and should not be considered a general rule. It also emphasized that the payments were being made as a reimbursement to the parent and not a direct payment to the school. The Vermont Supreme Court plays yet again another role in the story of tuitioning in Vermont in the 1999 case Chittenden v. Department of Education. In May of 1996, the Chittenden Town School Board authorized payment to Mount St. Joseph, a Catholic school in Rutland. The following year, 15 students from Chittenden enrolled at Mount St. Joseph. When the board voted to allow tuition payments to Mount St. Joseph, the Commissioner of Education terminated state aid payments to the school district, citing a violation of the Establishment Clause of the United States Constitution and the Compelled Support Clause of the Vermont Constitution. The court, not unanimously, ruled in favor of the Department of Education, stating that including religious schools in the town tuitioning system was a violation of the Compelled Support Clause of the Vermont Constitution. Another case comes in 2001, this time in the U.S. Second Circuit Court of Appeals. The case involved a student with an IEP in the St. Johnsbury School District. St. Johnsbury is a tuitioning district with most students attending St. Johnsbury Academy. The student had an IEP upon finishing 8th grade that required placement in regular education classes for both English and social studies in 9th grade. As the student finished 8th grade, they enrolled for placement at St. Johnsbury Academy for the following year. The academy denied the placement because the student did not satisfy a 5th grade ability requirement. The family challenged the academy's position during a special education due process hearing, and the hearing officer ruled in the student's favor. The academy appealed the ruling to the district court, which upheld the decision. The academy then appealed that ruling to the Second Circuit Appeals Court. Upon review, the appeals court overturned the prior decision. In the ruling, the court held that the Individuals with Disabilities Education Act applies only to the state and other public agencies, not to private schools in which public agencies may place children. In coming to its decision, the court noted that the family, the school district, and the Vermont Department of Education all conceded that St. Johnsbury Academy is not required to accept all students from St. Johnsbury. In late 2016 and early 2017, an attempt by the State Board of Education to update the 2200 series of rules are met with pushback from independent schools and legislators. A proposal would have required that private schools accept all special education students, be accredited by the New England Association of Schools and Colleges, require certification for teachers, and comply with new financial documentation requirements. Both independent schools as well as legislators pushed back on those requirements. The body in charge of the rulemaking process blocked the State Board of Education's proposed rule from moving forward. As a response to the State Board's efforts, a group of legislators proposed stripping the State Board of Education of their rulemaking authority. By late January of 2017, the State Board of Education said that there had been a misunderstanding and that the original draft never intended to apply the same set of rules to private schools as public. In 2018, the legislature passes Act 173, intended to enhance the effectiveness, availability, and equity of services provided to students that need additional support, including students receiving special education services. Related to tuitioning, the law required that private and independent schools intending to receive public money cannot deny enrollment to students based on special education needs. The law further required that the State Board of Education update the rules necessary to implement the Act, the same Rule 2200 series that was problematic in 2017. In 2021, the State Board completes work on the update to the 2200 series of rules required to implement Act 173. The resulting rules place requirements on independent and private schools seeking public tuition money. Critics argue that the rules don't go far enough, since private and independent schools can still maintain enrollment criteria and could deny admission to students for reasons other than those prohibited by the rules. 2022 brought a lot of activity in the tuitioning space. In June, the Supreme Court decided the Carson v. Makin case in Maine. In its ruling, the Supreme Court said Maine's tuitioning system violated the Free Exercise Clause of the United States Constitution because it denied payment to religious schools based on their religious exercise. The impact in Vermont came shortly after that decision. In September, the Secretary of Education in Vermont sent guidance to all schools in the state that they could no longer deny payments to approved independent religious schools. Then, in late September, we learned that the state, together with several school districts, settled 2 cases involving 5 families by agreeing to pay tuition and legal fees of approximately $95,000. Current Vermont statute allows school districts to designate up to 3 schools for its children to attend. It remains one possible solution that could allow non-operating districts to limit where the public tuition dollars are sent. Designation requires that both the sending school district and the receiving school agree to the arrangement. In early November, the Board of Trustees of Burr and Burton Academy took that option off the table for the Taconic and Green School District by stating that they would not accept designation from the school district. It's worth noting that Vermont's newly elected Attorney General, Charity Clark, sits on Burr and Burton's Board of Trustees. And also in November, another case was argued in the Vermont Supreme Court. In the case of Vitale v. Vermont, the plaintiffs argue that the state's tuitioning system that allows some students to attend the school of their choice while others are unable to do so results in educational inequity and is a violation of the Common Benefits Clause of the Vermont Constitution. The court heard oral arguments on the case on November 29th, and a ruling is expected in 2023. So, what will come in 2023? Well, it's impossible to know how things will settle out next year, but one thing is certain. 2023 will be another important chapter in the tuitioning story of Vermont public education. Thanks for listening and sticking around to the end. I hope that this has been informative.